The Ninth Circuit Court of Appeals flipped again on our lawsuit May v. Bonta, which is a challenge to sensitive places on Senate Bill 2, but this time in favor of the firearms community. Let's talk about it. Hey everybody, welcome back to the channel today. We got another flip-flop in the Ninth Circuit Court of Appeals, this time in favor of the firearms community here in California. If you haven't seen news on this already, I am talking about May v. Bonta, which was our challenge to the sensitive places portion of Senate Bill 2. Here to talk us through it today is Costas Moros. He is an attorney at Michelle & Associates and the primary writer on this specific lawsuit. Costas, how are you today?
Good, Kevin. Thanks for having me on again. I'm great. I'm great, in fact.
Absolutely, and looking forward to it. But before we get to that today, guys, it is helping. We're reigning in the new year. We're trying to grow this channel, so please be sure to like, share, and subscribe to these videos. It really helps with the algorithms. Hit that notification bell so that when the court keeps flip-flopping, you get a notification every single time that we put out a video so that you can be sure you're abiding by these archaic laws here in California. But for now, let's just jump on into this, Costas. So, and actually, I want to kind of get the... I want to kind of encapsulate this entire roller coaster that we've had since basically the new year. We obviously had this challenge. We got the court date that we wanted. We were able to get an injunction on this portion of Senate Bill 2 for the sensitive places. Guys, we've got those videos in the description below. If you have not heard about this case in general, please be sure to check out those videos as well. But on December 30th, this is after we had gotten the injunction. Jacob, if you can actually pull this up, because the state obviously appealed to the Ninth Circuit to get a stay on the injunction that was placed by Judge Carney from the Federal District Court. And the court came back and said the district court's preliminary injunction issued on December 20th, 2023 is temporarily stayed pending resolution of the motion for a stay pending appeal by the merits panel. In granting this administrative stay, we do not intend to constrain the merit panel's consideration for the merits and appeals in this way. The existing briefing schedules remains in effect. And this is going to be important for the next question that I want to ask you. But Costas, what exactly happened here on December 30th, the day before this law was originally supposed to go into effect, but we thought that we had gotten an injunction on it. What actually happens here with this stay that was put on?
Sure. So the state was appealing the injunction, and it also filed what it typically does when we win an injunction, which is an emergency motion with the Ninth Circuit to stay the injunction pending appeal. What was unusual in this case, of course, was that it wasn't like our magazine case or any others where we were enjoining a law that was in place. Instead, we were stopping a law from taking effect. So the status quo was on our side in this case. And so they appealed, and typically these sorts of emergency motions are handled by a motions panel, which is 3 random Ninth Circuit judges that are rotated on a monthly basis. So every month, as far as I understand the rules in the Ninth Circuit, every month 3 judges are selected who handle just emergency motions. So in any case, not just gun cases, in any case. And they took the unusual step this time. It is in the rules, but it's rare. They took the unusual step of not deciding the emergency motion. Instead, they placed an administrative stay without deciding anything and let the law go into effect, which is unusual because administrative stays are supposed to preserve the status quo. So that's what the motions panel did. They basically washed their hands of the thing, placed an administrative stay on it to help the state, I guess, in this case, and then handed it off to the merits panel, who will actually decide the appeal.
Well, let's talk about that administrative procedure really quick. And in order to do that, you know, obviously once this happened, the messaging campaign got real, right? We thought that we had the injunction on the sensitive places. So the firearms community was taking a breath. Okay, we're going to be able to carry coming into 2024. And then they slam us with this. But, you know, we then were able to go and file for a motion for reconsideration. If I'm correct, it was a motion for reconsideration, right?
Yes, it was a motion for reconsideration or in the alternative clarification. And the reason we did that was because, as I said, the administrative stay they placed on it made no sense. In our motion, we cited three recent Ninth Circuit cases that expressly said that administrative stays are about preserving the status quo. They're about holding things in place until they could reach a decision on the merits. But this administrative stay reversed the status quo. California had never banned carry in these places, but by administratively staying the injunction, that allowed the law to go into effect for 6 days until, of course, we got the ruling that we're going to talk about. But so it was a very unusual move, and I'm not sure. I hope that the three judges on the motions panel just didn't realize what they were doing. Like, it was holidays and they were just trying to they didn't want to deal with this, so they just did an administrative stay without thinking. The less charitable explanation is it was malicious. They wanted to let the law go into effect. They knew we were right in our opposition to the state's motion for emergency stay, so they basically did an administrative stay so they wouldn't have to explain anything and handed it off. So choose your own adventure, I guess.
Well, this is something definitely to that we can take in and learn from. These appeals don't necessarily go directly to the three-judge panel that we see hearing oral arguments, and this is a great example. So if you can, go ahead and differentiate these things for us, because both in the decision that they made to lift the stay and to put it in place, which was prior, they did mention a merits panel. They did mention what was the other panel that they mentioned? There was
the
merits,
motions panel and the merits panel.
right? The motions panel and the merits panel. Obviously, what we're talking about when we see these big decisions would be part of the merits panel, and especially when you have a preliminary injunction, that indicates to the firearms community that our lawsuit is likely to win on those merits. So it can get really confusing when you see a stay put on an injunction where the merits have been told to us by a judge that they're likely to succeed. What is the difference exactly, not just in the panels for motions and merits, but in the administrative process? Is it always one before the other? Does it always start with motions and end with merits? How does that actually work in the Ninth Circuit?
Well, the motions panels only get involved if there is an emergency motion of some kind. So if the state had just appealed this, Judge Carney's ruling, but didn't try to stay it, and in fact, they just let the injunction be in effect through their appeal, then a motions panel would not get involved. It would just eventually go to a merits panel. The motions panel is only involved to decide emergency motions like this. And it is in the rules that they can do this, that they can pass it off to a merits panel, but it is an unusual step. The whole point of a motions panel is to decide motions pending, appeals. So it was a little unusual. And it was also unusual that it took 6 days to get it reversed, because the rules say that when a motions panel does this, they should immediately draw a merits panel to decide the underlying motion. And maybe I'm being too harsh, because 6 days in court time is light speed. Maybe this is an immediate effect. But for those of us, all these tens of thousands of Californians who effectively lost their right to carry for a whole week, it didn't feel fast. We were pretty concerned that whole week that they were just going to leave this administrative stay in place. So we're relieved that that it was reversed. But yeah, it was definitely a long week.
Well, then you do get the court to see those arguments, and I did read that motion for reconsideration. It did rely heavily on the status quo. It did rely also on the arguments that you just explained, just to explain that administrative stay. But then we do get this, and Jacob, if you could pull this up. The court states the emergency motion under Circuit Rule 27-3 for the stay pending appeal for an interim administrative stay. The supplements, responses, and replies thereto have been referred to as the merits panel, and the case is calendared for argument in April. The administrative stay previously entered is dissolved. The emergency motion under Circuit Rule 27-3 for a stay pending appeal for an interim administrative stay is denied pending further order of the court. So obviously we got what we wanted here. There were, there was about a week where we, were at risk, and I kind of wanted to talk to you about that too. But I mean, let's not mistake things here. at the end, we did get what we wanted. That injunction is again in place, and that's the important information here. But what kind of damage could have been caused? You know, you have people who aren't necessarily paying attention to these decisions coming out of the court. You have people trying to live their everyday lives, and whether or not they want to carry or can carry is obviously dictated by, you know, these motions and these stays and these injunctions and all of this stuff. What kind of potential damage do you see when the court continues to flip-flop back and forth like this, especially in at such a rapid pace?
Well, it's incredibly damaging. I mean, what the motions panel did, again, I hope it was just a misunderstanding and they didn't really realize what they were doing because it was the holidays. But when you, so everyone heard the news on December 20th about this injunction, everyone who carries. But on December 30th, when you issue an administrative stay on New Year's Eve weekend, you know, it's a holiday weekend. People probably aren't really following the news. So I wonder how many people, you know, I'm constantly connected to this stuff because it's my job, and, you know, so other people are as well. But I'm sure, you know, out of the over 100,000 Californians with a CCW permit, probably many thousands of them were not following the news on a holiday weekend. You know, they're just out living their lives as they should be. So come January 1st, I'm sure a lot of people still had not heard about the administrative stay and probably have been carrying illegally all week until they heard about it, or maybe they never heard about the administrative stay. A few news articles covered it, but it wasn't like it was top of the news everywhere. You know, you had Gavin Newsom cheering it on, but that's about it. So it's really damaging. This is why the status quo is important. You know, it's really damaging that the court went ahead and reversed the status quo in effect and let a law go into effect. And now, thankfully, it's flipped back. But hopefully that is the end of the confusion here, and we will hold on to this injunction pending appeal. And of course, we hope to prevail on appeal, and it's looking good for us considering the same panel that lifted the stay is the one that's going to decide the appeal, the merits panel. So we don't know who the judges are on it, but the very fact that they lifted the stay and didn't even partially grant the state what it wanted is a good sign for us.
Well, something we are certainly going to continue and follow along with. I guess, Kostas, what are your final thoughts on this? It says in this document where they dissolved the administrative stay that April seems to be when the arguments are calendared for. What's the likelihood that something crazy happens between now and April? I mean, I guess you've already stated that it looks good given that the panel, even though we don't know who they are, did already lift the stay. But exactly how optimistic are you moving forward with this?
I'm pretty optimistic that nothing further is going to happen until the appeal is decided. You never know. I guess in theory, the state could go ask the Ninth Circuit en banc to reverse this, but that would be a craven political move for them to do. I put nothing past them, but I don't expect that at this point, because again, the state knows the status quo is on our side, so it would be kind of insane for the Ninth Circuit en banc to get involved in a procedural stay pending appeal when the status quo is merely in effect. You know, it would be a new low, I think, if they went ahead and did that. So I don't expect it at this time. And I think we're good at least through April and after that, because then April's just the oral argument, but I assume the court will take at least a few months, if not more, to actually issue a ruling after that. And that's when the fight begins, because if I'm correct that we have a good panel and we prevail, I'm sure the state will then seek en banc review, and you know, we'll go through the usual rigmarole and maybe even climb up to the Supreme Court if we have to, should we get a bad Ninth Circuit en banc ruling. But that's all speculative right now. For now, I'm just happy that Californians have their right to carry restored. Tyranny week is over, thanks to CRPA and all the other plaintiffs like Second Amendment Foundation, GOC, all of them. Yeah, I'm very grateful that the merits panel agreed with us and lifted the stay.
Well, yeah, and certainly the optimistic side of that is that the status quo has been maintained while we continue to litigate this, regardless of how long the litigation actually takes. Well, Kostas, I want to thank you very much. I know you're a busy guy, so thank you again for coming on and sharing with us. Can't wait for the next one.
Thanks, Kevin. A pleasure as always.
Absolutely. And guys, if you like this video and want to see more content like this, please Once more, it really helps us with the algorithms. Be sure to like, share, and subscribe to these videos. Hit that notification bell so that you are notified as this news comes out. Obviously, we're trying to break it to you as quickly as we can, so those notifications can be pretty important so that we can continue and be law-abiding in this state where it is extremely difficult to do that sometimes. Well, thanks, guys, and we'll see you on the next one.